Hey, it's James, Fathers Rights and Resources, hashtag how I got custody. Here's part two of how inadmissible evidence is inadmissible in court. I have to do a part two because there's just so many plain examples that people should use to help paint a picture. I did a video on YouTube a little bit ago. You got to paint a picture in court. These judges are stupid. Think about this. These judges were typical moronic idiots who became an attorney. You know how like a lot of engineers, they got no common sense. You know, there's, I don't know, what is it, civil engineers or civic engineers that do the roads and stuff? Look at how some of the roads are and how exits and on-ramps. We have issues in Washington where they've worked on this one on-ramp and off-ramp area near Tacoma, Washington, literally for about 25 years. They keep changing it. Who's the stupid jackasses who's got degrees in engineering that keep having to redo this over and over again? They have been constantly building and rebuilding just different on-ramps and off-ramps, and the traffic still slows down. And one of the root of the problems is people can't merge, and they don't set it up where on-ramps and off-ramps are way separate from each other. They still got them jammed together, so people are still going to get stuck. But these judges are idiots. They used to be family law attorneys, some of them. And they're not going to follow the rules sometimes. So you have to remind them what the rules are or argue what the law says. And when a judge says, when a judge says something like, you know, don't tell me what the law says, just tell me the facts of your case, or don't tell me this. I have a right to tell you this stuff. I have a right to talk in court about this. So, there's case law in some states. I know we got in Washington State that says when the rules of evidence are violated, so you have to paint a colorful picture to make them understand this stuff. They used to violate the rules and evidence rules as attorneys all the time. And now they're here violating it as a judge because they're doing what they used to do and they don't care. You got to make them care. So I would use examples like this. You know, I gave an example of when, you know, arrest somebody for possession of drugs and you did, like, sometimes the cops, they know they got a drug dealer. They'll try and say, oh, you had a taillight out. Oh, I smelled drugs. And they open the trunk and they didn't have a warrant or probable cause. They can get the stuff thrown out, and it's inadmissible. It's not allowed in court because they will honor the constitutional rights on search and seizure. Even if they know they got the guy and he's guilty of sin, they want to honor the rights to due process and against warrantless searches and seizures and stuff like that. Well, case law in Washington and some other places in federal court and stuff says that when the rules of evidence are created to have a fair hearing. If you don't have a fair hearing, the courts are supposed to be fair and equitable. If you don't have a fair hearing, then somebody's cheating. And you have an unfair disadvantage. You don't have a fair hearing, then what happens? If it's not fair, then you don't have the process that's due to you to be fair. You don't have due process. You have a violation of due process. So then the judgment is void. If somebody cheats in a track meet or in a weightlifting competition in the Olympics, and that by using steroids, they cheated, it's not fair, they had an unfair advantage, they will wipe out their gold medal and give it to the silver medal winner, right? If you use your hands in soccer, the rules are you have to use your feet except for the goalie. If somebody grabs the ball and starts running with it like it's a football game, American football, they will blow the whistle. That's cheating. You're violating the rules. But according to this judge, like the example I gave, don't object to that right now. We'll deal with it later. That would be like a soccer game where somebody grabbed the ball and picked it up and started running with it, and a coach said, call a penalty. He's using his hands. Call a handball or use of hands, illegal use of hands. And the ref says, hey, look, just deal with that. Wait till he scores a goal, then we'll deal with it. That would be asinine. Or if somebody is carrying a football and they run out of bounds and they go all the way down the sideline out of bounds, and a coach says, hey, he's out of bounds. Watch the replay. He stepped out of bounds at the 40. That's not a touchdown. And the referee says, save your objections some other time. Wait till the end of the game and see if it's a close game. That would be asinine for the ref to do that. The referees in court are the judges. The courts have rules to make sure everything's fair. If they violate the rules, it's unfair and the other side's cheating. If an attorney can come in and say, oh, the father's going to get violent, or the way the father, the guy I was talking today, the attorney kept saying, well, the father's really rude and obnoxious in our correspondence. That has nothing to do with his parenting. The attorney was setting him up, saying provocative, hostile things in emails, and now they think that that's admissible as relevant evidence. It's not. It has nothing to do with the child or the parenting. And the attorney was rambling on, and this happens a lot. Oh, the father's going to do this in the future. The attorneys aren't allowed to be psychic. And the attorneys aren't allowed to talk about child psychology. And the attorneys aren't allowed to, I mean, in this particular case, they weren't even arguing, how bad the father was. And the dad got so caught up in emotional, he missed every single point I was talking about with the rules of evidence. It's irrelevant to talk about my conversation with an attorney that has nothing to do with my parenting. It's not even in the factors in the law of his state. If that was a factor, then every single attorney who talks hostile to somebody should get their kids taken away if we apply their logic. See, if you turn around and apply what they're saying to them, then you can say, oh, we need to round up every kid of every family law attorney because they act hostile toward people all the time off the record. So according to their logic, their kids should get taken away by CPS or a judge. That doesn't make any sense. But when you point it out and paint a picture like that, or you use a sports analogy, you're not allowed to violate a rule and they say, oh, the coaches need to complain some other time. No, they can complain now because the rule is being violated and the ref missed it. The evidence rules are being violated now. So you have all this stuff. The attorney is acting like a psychic and predicting that I'm going to do this. The attorney is saying, I secretly did that and nobody was there to witness it. That's ER 602. The attorney is talking about me having a mental disorder. There's no psychological evaluation that says I have a mental disorder. ER 702. Everything out of their mouth is not admissible in court. It's not allowed in court. You can't say, when I say objection inadmissible, objection personal knowledge, objection the attorney testifying, objection expert testimony, and you don't like it because I'm interrupting the attorney, that attorney is the expert in the law and in the rules. Why don't you make that attorney play by the rules instead of getting mad at me for calling them out for violating the rules because you don't want to embarrass them? Why don't you tell them to act like their law degree is worth the paper it's written on and follow the rules? They're the geniuses. Why can't they argue? Because they won't argue the merits of the case because they don't have any merits. What they're trying to do is throw as much mud to the wall as they can, throw a bunch of hot air, histrionic, over the top, empty allegations that have no merit. And the allegations on their face are not even allowed because it's the attorney testifying. It's not written down in any declaration by any witness. The attorney's just making it up. So attorneys can just walk into court and just make up imaginary stuff and they get to keep talking? Is that what this guy didn't want to piss off the judge. He actually talked to me during his lunch break at trial. He didn't want to piss off the judge. So I said, why don't you just say, Your Honor, respectfully, you can't allow this stuff because violation of the rules, violation of due process, makes a judgment void. That stuff is inadmissible now. What you really should say is, why don't you take control of your courtroom? You have a duty of care to follow court rules, due process, and you took an oath to uphold the Constitution. And constitutional case law says I have a right to due process and a fair hearing. This is not fair in any shape or manner. You need to cease and stop this. They can let them argue all day on the merits. Let them argue what was wrong with my parenting when I was seeing the kid. But they can't do that because I have no case. They're just coming in with a bunch of hot air. Stop these antics and demand that they argue based upon actual evidence.